If you have a situation in which your parents have executed a will, and at some point in time they have decided that you are no longer a beneficiary under the will, you do have certain recourses, but it is dependent upon the certain facts that are associated with the manner in which your mother and or your father, and it'll be determined by which will we're talking about, actually executed the will or signed the will or entered into the will. And the first thing that we want to look at is, at the time that they executed the will, were they operating under what we call capacity? Did they know who they were, who the president was, who were the objects of their bounty, what assets did they own? And did they have the sufficient capacity, mental capacity, to make an intelligent decision at the time that they did this? Your obligation is, at that point, if you want to contest the will, is to question that capacity. And the way in which you question that capacity is to secure witnesses as to the time that the will was executed, secure medical information or records to determine whether your parent did or did not suffer from a medical incapacity, such as dementia or Alzheimer's or some other type of mental illness that would have precluded them from making an intelligent decision at the time that they executed the will, because that is the critical point here. It's not whether they were unable to do it 2 weeks before, it's whether they had what they call a lucid moment at the time that they signed the will. If they did not, and they did enter this will, then under those terms without capacity, then you have the opportunity to file what they call a will contest or a petition with the orphans court in the particular county, which controls estates and wills, and raise the issue before the judge to say, I believe that this will was entered into when my parent did not have capacity to execute the will at the time the will was executed. The court will then listen to all of your evidence, which would be witnesses who were either present at the time of the execution or witnesses that know about their medical condition, and then the court will hold a hearing, and the judge will determine whether you have proven your case as to whether the individual had capacity or did not have capacity. The second way in which that you can contest this will is whether somebody had undue influence over your parent before they executed or at the time that they executed the will. And this criteria is a little different than at the time that they actually signed it. It's whether someone was influencing them when they had a weakened mental intellect or a weakened medical condition that precluded them from actually understanding what they were doing and whether they were being forced or influenced into doing certain things. We have this situation sometimes with healthcare providers that are there every day, with long-lost family members that arrive unexpectedly at the household and come in, and now they're the best friend of your parent while you're away at a different state. And they start, in effect, influencing that individual to say, hey, benefit me. And at that point in time, your burden is you have to show the undue influence, you have to show the weakened intellect of your individual parent at the time that they were subject to the influence, and then you have to show that the person who actually benefited from the will actually did get the benefit. And that is also determined by the court through the process of a hearing after evidence is produced. This is somewhat of a short answer, but basically what you're looking for is individuals that have influenced your parents, had access to your parents to influence them, were in a confidential relationship with them in the terms of they were a power of attorney or an agent, or somebody who had access to gain some influence over them to change their minds against their will because of their weakened intellect. And that's how you can contest the will.